What we want to do now, in order to try to make sense of the application of implied trusts, is look at them in the context of sharing homes, because I think that makes the most sense to most students, because we can all identify with it. So let's think about the social context. Broadly speaking, if we have married couples or couples in a civil partnership, then any distribution of assets following relationship breakdown will be governed by a statutory framework as set out on the slide. The couples or relationships we need to consider are where there is no marriage or civil partnership in place. And in those circumstances, what we need to do is look to property law to resolve any disputes and arguments. So what you should look for, first of all, is whether or not an express trust has been created, because as you know, if we have the three certainties present and a trust has been validly constituted by following the correct formalities, then the beneficiary will have an enforceable interest in property and can go to court to enforce the terms of any trust. In the absence of an express trust, then we're looking at the subject matter of this series of lecture notes, implied trusts. And what we've seen is that if you can demonstrate that there are circumstances where the law would presume that there's an intention arising when somebody has made a contribution to the purchase of an asset, or whether they have voluntarily transferred property to another, then you might be able to raise arguments around resulting trusts. Although at this point it now has to be said that the law has developed broadly to say that resulting trusts concepts shouldn't be used to resolve disputes over the family home. So they can be used to resolve other disputes between individuals who jointly share property, but their application to the context of the family home has been closed down, as we'll come to see. So that leaves us with looking at the principles around constructive trusts to help us out, and that's what we've been considering, and we'll go into quite some detail around that in just a few moments. Finally, there may be the possibility to raise what are called estoppel arguments based around detrimental reliance on promises made, which equity recognises and can, in certain circumstances, lead to an interest being reflected in property in favour of a beneficiary. So let's go through that in a little bit more detail then. The first option then is to consider whether or not we have an express trust in the home. Now, Lord Justice Slade in Goodman and Gallant said, if the relevant conveyance contains an express declaration of trust which comprehensively declares the beneficial interests in the property or its proceeds of sale, there is no room for the application of the doctrine of resulting, implied or constructive trust, unless and until the conveyance is set aside or rectified. Until that event, the declaration contained in the document speaks for itself. So remember the requirements for the creation of an express trust, and note that in the event that sufficient intention to create such a trust is lacking, then no such express trust argument can work at all. At that point, we're looking at implied trusts and the rules that we have already introduced this far. That said, what we do need to do is just understand where a resulting trusts analysis could get us to if those principles were in fact held to be applicable to disputes arising over beneficial claims to the family home. So these next 5 slides or so are best understood in context and in terms of historical development, because as I've said, broadly speaking, a resulting trusts application will not be possible now in the context of the family home, but that certainly wasn't always the case. So I'm just going to backtrack a little bit to explain historical approaches to determining disputes of this nature, and then move on to explain where we are now. So back to the notes on resulting trusts. Well, if we apply those in the context of the family home, what we'd be looking for here is whether or not there's been a voluntary transfer of property from one person to another, or where somebody's made a contribution to the purchase of the property, which is actually held in somebody else's name. And again, have a look at those two cases that we've cited before. So moving on, just take a minute to look at what's on the slide. Where we've got a contribution to the acquisition of family property, where A pays for the purchase of property which is vested in B or in their joint names, then A will be entitled to a proportionate part of the beneficial interest in the property, and broadly speaking, it's going to be a question of how much was paid. So the equitable interest, as we see, it's based on the financial contribution. It's got to be direct, and again, that echoes Lord Brown-Wilkinson's judgment in the Westdeutsche case. If we look at a very, very old case, Dyer and Dyer established that the clear result of all the cases, without a single exception, is that the trust of a legal estate results to the man who advances the purchase money. I mean, we've got to remember that this was 1788. You'll find that the language of these judgments is gender biased, because historically we have found that it is normally wronged women claiming some kind of intervention from equity as against their male partner. Obviously that's not always going to be the case, but actually in the vast majority of reported decisions the gender distinctions are fairly traditional. So forgive me if that annoys you, but it's reflecting the historical position. Now that may be all well and good in a commercial context, but let's just take a quick look at what happens when these principles, these resulting trust principles, are applied. So let me just talk to you about the case of Pettit and Pettit and then Gissing and Gissing to move us on a little bit. Now, what I've just said is all well and good in a commercial context, but let's interrogate whether that actually works in a domestic setting. So we've already considered resulting trusts, whereby interests are asserted on the basis of the amount of money which each party has contributed to the property. Let's see what happens when I give you the brief facts in relation to Pettit and Pettit and Burns and Burns, and you decide for yourselves. Well, Mrs. Pettit inherited a house. Now, having said that these cases very often reflect fairly traditional gender roles, actually this is a case where she was the property owner nevertheless. Mr. Pettit undertook some DIY jobs on the property. The court found in due course, when there was a dispute, that he had not acquired an equitable interest because only contributions to the purchase price or substantial contributions to the property itself would suffice, and DIY was not understood to be a substantial contribution to the property. Okay, what about Mrs. Burns? Well, she raised a family in the property. She had worked and had given up her job, and that was in order to raise the family. She had made the home and created the home and brought up the children until they were adults. Now, when it came to understanding contributions which might give rise to a claim, the court said that those contributions that she had made effectively in these terms were to be discounted and could not be used to raise an argument that she had acquired a beneficial interest in the home. So that's the sort of outcome you get to if you insist that the only things that matter are direct contributions to the acquisition of the property or substantial improvements to it. So you will have your own view as to whether or not that's right or wrong, but does that really reflect an expectation or the real circumstances of how we live our lives? Let's also just recall, though, that it's not always going to be the case that where somebody has bought something that they will retain an interest in that, because the most common example where that's not going to be the case is where somebody does intend to make a gift. Okay, so we just remember the presumption is, first of all, that you intend to retain a benefit unless there is evidence that that presumption should be rebutted. The most obvious example, as I say, is when you intend to give something to somebody. Alternatively, it may be the case that you've just provided a loan to somebody, in which case that arrangement is governed by the law of contract, as you'd expect. One final thing to recall around presumptions is remember that in certain circumstances where you've got fiancés or husbands and wives or civil partners or parents and children, then the presumption of advancement may well apply to rebut the initial presumption that you intend to retain a benefit. Again, don't forget that the presumption of advancement itself is under review and that it's also rebuttable. Criticisms of the resulting trust's application to resolving disputes over the family home are as you'd expect and as we've briefly gestured. Of course, they're restricted to understanding contributions in financial terms only. Now, if you remember Valerie Burns, that is a problem, isn't it? You know, is it legitimate to argue that rearing children and making the home is any less important than going out to work to pay the mortgage contributions to acquire the bricks and mortar? Because the resulting trust application says that it is more important to go and buy the bricks and mortar. Now, that may jar with many of you. You'll have to start to think about this in the specific context of the family home, and we will go through different conceptions of the way in which interests are recognised in a moment. So as you can see, if you go down the financial contribution route only, it means that whilst you get certainty on the one hand, you of course lose the flexibility to be able to make any arguments based around any other form of contribution at all. Inevitably, that's going to favour men as opposed to women, because obviously women in a standard heterosexual setup are the ones to rear the children, certainly to give birth to the children. That generally means that they are unable to work for a certain period of time, and it means, broadly speaking, that they're going to be inhibited from going out to earn the money to make the direct contributions the law would so require. So that there seems to be a sort of inbuilt prejudice there, or an inbuilt bias in the formulation, if that's the one that is prevalent. And it's, broadly speaking, for this and other reasons that Baroness Hale in particular has said in Stack and Dowden, which was affirmed in Jones and Kernet, that resulting trusts formulations have no place in determining interest in the family home. So we will move through the next few slides, and that will explain the development of the law in this area, and when we come to the end, you will be able to reflect all the way back on all of these formulations and work out which for you is the most successful way of determining conflicting interests or conflicted or disputed interests in the family home. So that said, if I can take you back to the 1970s, 1 year on only from Pettit and Pettit sees the case of Gissing and Gissing decided. Let me just tell you the facts briefly, because this case is often understood to be of central importance because it's a starting point in the discussion of all subsequent decisions. So it's very important for you to get a grasp of this decision. The house in the case was owned by Mr. Gissing in his sole name, even though it had been bought by a mortgage and a separate loan which had been made to the couple by their common employer. So fairly common at the time for property to be registered in a sole owner, even when the parties are married, and even when she is jointly contributing to the mortgage and has indeed undertaken a loan as a joint party, in this case made by their joint employer. Now, on top of that, Mrs. Gissing spent £220 on laying a lawn and furnishings. Again, you have to just remember the time of this when you're thinking about the financial contributions. Obviously £220 is a lot more then than it is now. But at the end of the day, it was held that she had made no contribution to the purchase price and therefore acquired no beneficial interest in the property. So what's the point? Why am I making reference to this point? Well, it's because in the case it was recognised that the parties were not restricted to claiming interests which flow only from demonstrating a direct contribution to the purchase price, but that if there was a common intention that both should have such an interest, then a constructive trust will arise. So whilst on these facts it went against Mrs. Gissing, nevertheless the door was opened for a different way of determining interests in the family home. So again, let me just reiterate that the court said, look, direct contributions are one thing, but actually what we're interested in is an understanding around a common intention, i.e. an intention shared by both parties that both of them should have an interest in the family home. If that's successful as an argument, then a constructive trust will arise. This is okay to some extent, but you've got to ask yourself, to what extent is there likely to be a common understanding as to the respective interests in a property when everything in a relationship is going well? It's normally when the relationship's broken down that parties turn their attention to that. So this idea about common intention is not without its difficulties. Okay, so just bear that in mind as you have a look at the slide there, and then note on the next slide that, of course, Denning liked this idea because it meant that he was able to effectively determine or discover or find things like common intentions, basing his arguments or judgments on this idea around good conscience and making sure that, broadly speaking, wronged parties obtain some kind of proprietary remedy. So this is what gave rise to his new model constructive trust that we've already looked at in passing. So again, in your own time, go back to Hussey and Palmer, but then also have a look at Eves and Eves as well. But remember, in 1984, English law rejected the sort of wider conceptions of determining proprietary interests in favour of an analysis based around more direct and financial contributions, as we've seen in the case of Valerie Burns. If you're the kind of lawyer that seeks certainty in all things, then you need to return to the text of Lord Bridges' judgment in Lloyds Bank and Rossett. So just to remind you on the next slide then, what he's looking for is an agreement which is express and that you can prove. Alternatively, he's looking for an implied agreement, but the way in which he will recognise that implied agreement is by looking for direct contributions to the purchase price of the property or payment of the mortgage direct. Now, many courts have been keen not to allow too much discretion to the judges. So in those sort of circumstances, this type of approach is appealing. So that has been the preferred approach for many judges in many courts. And as we've seen, this gives rise to what was known, or what is known, as the institutional variety or institutional version of the constructive trust, as opposed to the remedial constructive trust championed by Denning. So what you might say is that Lloyds Bank and Rossett can be undesirable on principle, but it has the advantage of clarity. The cost of clarity in this sort of circumstance, though, is generally going to be borne by the female partner to the relationship for the reasons that we have already discussed. Now, all of these tensions get played out in the text of the judgments. So let's just have a look at a few cases on the next few slides, just to get a flavour of the nature of the discussions in this sort of area. All right, well, where we're looking for express discussion, you can see the court's reticence to try to infer much into the minds of the parties. Look at the quotation from Springett and Defoe there. Our trust law does not allow property rights to be affected by telepathy. Walsh and Singh forecloses an argument based around joint venture, saying evidence of that won't suffice. And back to Lord Bridge, even the clearest oral agreement to confer an equitable right in land will be ineffective if not in writing, unless the claimant can show that she has altered her position in reliance on the agreement, thereby acquiring an enforceable interest by way of a constructive trust or of a proprietary estoppel. And again, we'll come to proprietary estoppel a bit later. So look at the hurdles put in the way of the potential claimants by these sorts of formulations, and you consider whether or not you think that the law in this area at that point is fit for purpose. And very often when we're talking about making these sorts of claims, we're looking for evidence of any sort of detrimental reliance on an agreement that is understood to be in place between the parties. So how do we understand detrimental reliance? Well, again, have a look at some of these cases. Detriment's got to be over and above that expected of cohabitees. It's got to be referable to the bargain, to the agreement, to that common intention between the two parties. So with this formulation, it's almost like saying, well, there has to be some sort of almost contractually recognisable agreement between the two of them. And further, it's got to be unconscionable. So that concept again, for the legal owner to go back on the agreement knowing that the other parties relied on it. So it really is pushing a boulder uphill, this, isn't it? The main difficulty in all of this is that really, is there going to be an agreement between two parties who've just set up home together, maybe even just set up a joint life together? Have they really sat down and talked about this? Have they even addressed their minds to it? Have they therefore got the chance to adduce evidence that their conduct, their words said, actually relate to the existence of something that we might conclude wouldn't really be in existence in the first place? So again, you know, trying to do the best we can here, trying to look for some sort of common intention is really not without its difficulties theoretically and conceptually, is it? Broadly, these are the constituent elements. The law is encouraging us to look for a common intention or a bargain between the parties. It's encouraging us to look for a change in position or detrimental reliance. Now, changing position and showing detriment isn't going to be difficult, but linking it back to that almost hypothetical common intention is going to be really quite difficult. The final concept for us to note is the concept based around something being unconscionable, this idea of unconscionability. Now that's something that we are seeing emerging in the judgment, and maybe that's really the best way forward. But again, I'm going to leave it for you to comb through these cases and get a real sense of how the law grapples with a very real and very difficult problem. Look at the range of solutions possible, and I leave it for you to determine which you think is the best approach. Of course, we'll finish the lecture telling you what the law currently says, but of course there's plenty for you to reflect on and cogitate. Now, it has to be said that the Rossett test has not been strictly followed, and many post-1991 cases in the Court of Appeal did rely on resulting trust principles based on the parties' contributions to the property. But very interestingly, this application of resulting trust principles allowed for adjustments to be made to accommodate later contributions. This is also known as the balance sheet approach to determining the respective interests in the property. So here the task is to list the financial contributions made by the parties, but as we'll quickly see, the Court of Appeal moved in a number of different directions, and the contributions which count have been held to be wider than those which Lord Bridge envisaged in Lloyds Bank and Rossett. So if we turn to this question as to the quantification then of the beneficial interest, well, if you've got an express agreement, it's easy to determine. You just point to that. The difficulties come when we're asking the court to imply an agreement and then look at what's understood to be the respective shares. So I said that the Court of Appeal moved in different ways. Well, let's look at the detail of Midland Bank and Cook. In this case, Lord Justice Waite stated that the court has to undertake a survey of the whole course of dealings between the parties. Now, this has led to the simple application of the maxim equality is equity in many cases. And what he said is this, so let me just read you an extract from the judgment. The duty of the judge is to undertake a survey of the whole course of dealings between the parties, relevant to their ownership and occupation of the property, and their sharing of its burdens and advantages. That scrutiny will not confine itself to the limited range of acts of direct contribution of the sort that are needed to found a beneficial interest in the first place. It will take into consideration all the conduct which throws light on the question what shares were intended. And it's the default position that equality is equity. So if we some of the basic facts then, as we've included on the slide, if you take a moment to see this, no agreement regarding quantification was expressed, but it was proven that Mrs. Cook had contributed 7% to the purchase price of the property through the medium, if you like, of the wedding gift that had been made to the couple. At first instance, she was awarded 7% of the value of the property then, but the Court of Appeal did what Lord Justice Waite has said he would do, and he's conducted a survey of the whole course of dealings between the parties, taken a very broad brush approach, and adopted, in this case, a 50-50 solution. On the facts, this question about what the respective shares should be couldn't simply be decided by reference to cash contributions made by the parties, and the court accepted that the parties had agreed to share everything equally, and this was based on facts which pointed to a shared attitude around Mrs. Cook bringing up the children, working both full-time and part-time on occasion to pay household bills, and that she'd also become a co-signatory to a second mortgage in due course. So do you see what I mean when I'm talking about the whole course of dealings between the parties, if you want to use that phrase, being scrutinised by the court? Now you'll quickly remember that this is completely different from the approach taken in Burns and Burns, and obviously it's very difficult to reconcile with that decision of the Court of Appeal in 1984. The advantage of this doctrine, though, is that it allows the judges great discretion, so of course it's understood to be remedial in nature as opposed to institutional. So again, this is why I think it's quite useful to bear in mind this idea that one conception is institutional, another conception is remedial. Which do we prefer and why? But do we really need to exclude one possibility in order to favour another? Can we find some way of adopting the use of either if it's appropriate to the circumstances. Of course, the big debate will be, well, in what circumstances is it appropriate to use an institutional approach? In what circumstances is it better to adopt the remedial So there are a couple of other Court of Appeal decisions that I'd like you to just take a quick look at while we're conducting our survey of these decisions at this appellate level. First one is Drake and Whip, and if I can just refer you to the text on the slides, that's self-explanatory. What I would like to spend more time looking at is the decision in Oxley and Hiscock. So if I can move us forward to that. Have a look at what Lord Justice Chadwick said. And then I'd like to read a further extract from his judgment to you. He went on to say, what the court is doing is to supply or impute a common intention to the parties' respective shares in circumstances in which there was in fact no common intention. On the basis of that, which, in the light of all the material circumstances, including the actions and conduct of the parties after the acquisition of the property, is shown to be fair. Now, this idea of fairness is expressed in a slightly different way, and the terminology being appropriated and adopted by the courts is one around unconscionability. It's an emerging doctrine, I think it's fair to say, and I'm picking this up from the work of Alistair Hudson. I'm sure you're familiar with his leading textbook, and I very much recommend you spending some time having a look at his take on this area of the law. The central question becomes, would there be any unconscionability in denying the claimant an equitable interest in the property? And what Hudson does is use this concept to pull together some very disparate decisions from differently constituted courts, because at this stage in the lecture, I imagine you're thinking, how on earth am I supposed to make sense of any of this? Well, of course, that's a good question, but broadly speaking, this is quite a good way of helping us to account for disparate decisions, but also look for some sort of common conceptual thread between the judgments. Here, the courts are allocating equitable interests in the home without needing to base that outcome on a finding of common intention between the parties. The approach tends to begin with a consideration as to whether or not the parties have in fact reached an agreement, but even then, the often vague finding of such an agreement is usually tempered with a consideration of the entire course of dealings between the parties. Some of the courts have then expressed their intention as being to do what is fair between the parties, as we've just heard. Now, the characteristics of this approach merge the doctrines of constructive trust and proprietary estoppel, and they do this in an expansive way. Contrast Lord Bridge, for example, in the Rossett case, who also sought to merge doctrines, but so that there could not be any flexibility for the courts. Courts are accepting that it will not be possible to generate any single set of principles which will cover all circumstances. And last year, I had the very great privilege of attending a conference where Lady Hale was speaking, and it was really instructive to listen to her talk about the process of judge making, of judging appeal cases at the highest level. And she really conveyed a sense of all of her colleagues and herself trying to do their best. And I was very persuaded by that, because very often I think we look for certainty, both for now but also forevermore, and that's a bit of a tall order. So in a moment, I'm going to be inviting you to consider the text of her judgment in the very famous case of Stack and Dowden, and then the subsequent decision in Jones and Kernet. And if you just bear in mind what she's expressed that she's trying to do, I think it will empower us all as lawyers to think of law as a tool and a framework, and not something that's scientific that tries to establish a hard and fast rule for every single circumstance. Okay, well, enough of me waffling on. Let me make this a bit more specific. So looking at the facts of Oxley and Hiscock, here we see a merger of the tests considered, especially the general law on constructive trusts, proprietary estoppel, and common intention constructive trusts. What were the facts? Okay, the claimant exercised a statutory right to buy using cash from her unmarried partner. The house was bought as a home for the couple and her children. The property was sold after relationship breakdown, and there followed a dispute as to the respective shares in the house. Ultimately, the Court of Appeal held that this was a case of pooling resources and found that Hiscock contributed £60,000 and Oxley £36,000. So split the property 60-40 in favour of Hiscock. So if you return to the words on the slide, and remember the other words I'd quoted from the judgment, these seem to encapsulate this unconscionability doctrine, which appears to be remedial in nature. Now, having made the point that trying to tie in the cases together under an umbrella sort of conceptual approach is quite appealing, actually Hudson argues against the approach as being intellectually unsustainable on the cases. So maybe we need to think about a new concept or developing existing concepts which would be sustainable intellectually on the basis of the decisions that we have before us. And again, I had the great privilege of attending a conference where Hudson himself was speaking, and he did rather intimate that we're never going to get this right, we're never going to solve it, but nevertheless, as students of law, it's always going to be absolutely fascinating to us, isn't it? Because it gives us scope to offer our reading of the cases and offer our version of the way forward. So there's a challenge I lay before you. This now takes us to the 2007 House of Lords decision in Stack and Dowden. So let me first start by reiterating the facts. Mr. Stack and Ms. Dowden began cohabiting in the early 1980s in a house in Ms. Dowden's sole name. Mr. Stack contributed to the deposit, but that deposit was paid out of Ms. Dowden's account. The balance was provided by a mortgage loan, which she repaid. They had 4 children and moved into a new home in 1993, registered in joint names. A further mortgage loan was taken out, this time in joint names, and under which both of them made repayments. Ms. Dowden paid all the domestic bills. They separated in 2002. The House of Lords awarded him 1/3 and her 2/3 of the equity in the property. It's significant that at the end of their relationship, Miss Dowden earned 2/3 of the total household income and he earned 1/3. And when you read the judgment, you'll notice that this represents a significant change in the law, where prior to Stack and Dowden it was very easy to displace the presumption that equity follows the law where land was acquired in joint names. As you recall, if parties had contributed unequally to the purchase price of land acquired in those joint names, then the presumption of joint ownership was rebutted in favour of the presumption of a resulting trust, i.e. that the parties owned distinct equitable shares in proportion to their individual financial contributions to the acquisition. Now, whilst at the end of the day we end up with a 2/3, 1/3 split, it's really important to read in particular Baroness Hale's formulation as to how she gets there, and I would refer you in very specific terms to paragraphs 69 and 70 of her judgment. By way of a very quick summary, the decision, broadly speaking, goes 4-1 with Lord Newburgh dissenting. Baroness Hale preferred the Oxley and Hiscock approach and the ability to look at the whole course of dealings, as opposed to looking simply at financial contributions. The remainder of the majority, so the other three, did express a preference for finding the party's intention and not simply looking for what is fair. So even in this court, as constituted by those five, you can see that 4 people reached their decision for broadly different reasons. Newburgh prefers to see these things decided along more balance sheet sorts of principles, and if you want to spend the time, then have a look at his judgment and read it in contrast to Lady Hale's, but of course remember that Lady Hale was leading the majority. And sorry, the only thing to point out on this slide is the typo. It's Newburgh that we should be referring to there under the second bullet point. Moving on then, what you'll discover is that the court spent some time discussing the potential to impute an intention to the parties. So we need to contemplate the difference between an inference and an imputation, and please have a look at the text on the slide there, which is a quotation direct from the judgment itself. The point to note on this slide in particular is that, well, obviously Lady Hale's judgment offers a chance to critically put some distance between Lord Bridges' decision in Lloyds Bank and Rossett and the current state of play. But let's just remember that in Rossett we had a house in sole ownership, and Stacking Down concerns a case where we had the house registered in joint names ultimately. So technically there's a distinction to be made, and it's going to be interesting to see what happens when the next case around a sole owner is appealed all the way to the Supreme Court. For now though, that's enough. But the second bullet point there is interesting, because what it's suggesting then in that case is that, broadly speaking, we should be looking to appropriate constructive trust arguments and constructive trust principles to the resolution of disputes around ownership of the family home, rather than relying on resulting trust principles. So that's the point to take with you from there. So some conclusions that we can draw are shown on the slide. Broadly speaking, the approach to calculating common intention appears to be broader. It's less based simply around financial contributions. This, however, is interesting when we do remember that the split was 2/3, 1/3, which broadly does represent the financial contributions made. So do you want to consider in that case then whether Baroness Hale's judgment in fact takes us any further than would have been the case had we applied resulting trust principles? Well, maybe not in the specific outcome of this case, financially speaking, but think about the potential for future claimants would be my advice here when you're trying to resolve that question. And the last one for us to consider is this idea around imputation. All right, we've talked about the difficulties of trying to find a common intention that might not be there. Well, if you go looking for something that doesn't exist, you're never going to find it. So perhaps the solution is to say, well, I'm going to impute it anyway, because that overcomes the problem of it not actually being there, doesn't it? Now, that idea needed clarification. So we need to turn to the next case of Jones and Kernet, where all of these issues were revisited, and it gave the court the chance to pick up this point around imputation of an intention. Moving to the Supreme Court decision in 2011, in Jones and Kernet. We've put the basic facts on the slide, but let me just give you a little bit more background. This concerns the rights of Mr. Kernet and Ms. Jones and their entitlement to a property which they bought in 1985. Ms. Jones paid £6,000 herself, and the remainder was funded by a mortgage. She paid the outgoings on the property, which included the mortgage and the bills, and he paid for some improvements. They split up in 1993, and at that point Mr. Kernet moved out and he made no further financial contributions to the property nor to the family home. The couple had realised the proceeds of a joint life insurance policy and divided it between themselves, and that enabled him to buy his own home in 1996. 13 years though after they had separated, he decided to seek repayment from Ms. Jones for his share of the property. As a result, she started legal proceedings and was seeking a declaration that she owned the entire beneficial interest. It was recognised that the couple owned the property equally when they separated, but Ms. Jones went on to argue that his beneficial interest had reduced due to his lack of financial contribution since moving out. In determining the outcome, the court followed the following principles. The starting point, where a family home is bought in joint names, is that the parties own the property as joint tenants, both in law and equity. The presumption can be displaced by evidence that their common intention was different, either when the property was purchased or later. Common intention is to be objectively deduced or inferred from the conduct and dealings between the parties. Where it is clear that they had a different intention at the outset or had changed their original intention, but it is not possible to infer an actual intention as to their respective shares, then the court is entitled to impute an intention, that each is entitled to the share which the court considers fair, having regard to the whole course of dealing between them in relation to the property. Each case is going to turn on its own facts. Financial contributions are relevant, but there are many other factors which may enable the court to decide what shares were either intended or indeed fair. Points for you as the critical student of law to perhaps ponder are whether the law is now unclear and whether the law is discretionary. Do you think that imputation applies to sole legal ownership cases? Remember that Stack and Dowden and Jones and Kernet were both joint legal ownership cases. And let's just think about precisely when the court is entitled to impute an intention to the parties. Does it apply at the initial stage when you're arguing that you've got an equitable interest in the first place, or does it only apply at the quantification stage? I'm going to leave that one with you. In determining your view, you'll want to pay attention to Law Commission reports on sharing homes, and also the 2007 report there, the financial consequences of relationship breakdown. So we've included those references for you. A different way of resolving the sorts of problems that we might encounter in terms of claiming equitable interests in property can be found by exploring the doctrine known as proprietary estoppel. So let's have a quick look at the facts in the Basham case cited on the slide there. The claimant in the case was 15 at the time when her mother married Basham. She worked unpaid in Basham's business and cared for him through a long illness. She also forewent the opportunity to move away when, having become married herself, her husband took a job elsewhere that in fact included accommodation with it. Now, all this was done on the basis that she would acquire an interest in the property upon Basham's death. In the circumstances, he actually died intestate, which then led to a dispute as to the rightful ownership of his property. In the case, it was held that the claimant had acquired an equitable interest on proprietary estoppel principles. So let's have a look at how you establish a claim based on proprietary estoppel. Well, first of all, we're looking for representations made, and clearly in this case it was always envisaged that actually the daughter would acquire an interest in the property. This then raises an expectation that should be fulfilled. What you need to demonstrate on top of that, though, is that you have relied on those representations and that that was to your detriment. So if we just take a look back at the facts of this case, well, it's not too difficult to see reliance in particular and acting to your detriment. Clearly, acting unpaid is acting to your detriment. If you're an employee in somebody's business, you would expect to receive a wage for that. In this case, our claimant didn't. What other factors were relevant? Well, having been married, if your husband moves away and you don't go with him because you're caring for somebody else in their property, well, you're foregoing the chance to enjoy your own married life, aren't you? And starting a relationship with your husband. So I don't think in this case it's too difficult to understand why the court ordered what it did. Now, talking of which, you'll see reference on the slide to the point that the court can award the minimum equity necessary. So let's just have a quick look at what that might amount to. Well, in the Greasley case, you can see that the claimant there was awarded a license to occupy the property for life. In Pascoe and Turner, the court ordered a transfer of the freehold, quite a substantial award there. In Baker, we saw compensation being ordered for the cost of giving up secure accommodation, and in Dodsworth, repayment of money spent on the property. So as you can see, the court has a range of solutions available to it in order to do the minimum to do justice in the case, you know, the minimum equity required to achieve justice. Which takes us to our final slide, so very well done for sticking with it. On the slide, what we've got effectively, I suppose, is a hierarchy or a checklist of things that you would discuss with your client if you're ever faced with the situation that he or she is trying to establish some kind of claim over property. So first of all, what are the client's legal rights? Let's start with the law. If you're a registered owner of land, then that's going to be much easier to deal with than somebody who's trying to claim some kind of equitable interest where there's no sign of that on any title documentation. So if you haven't got that, if you haven't got any evidence on the face of the title documentation, or if what you're trying to claim is more than is suggested by the legal title, then you're looking at trying to establish equitable claims or equitable rights, aren't you? So look first of all to see whether or not the client is in the fortunate position of being an express beneficiary of an express trust. We've looked at all of the requirements for the establishment of an express trust based around three certainties, formalities and constitution. If you're not able to make that sort of claim, then what you're looking at is establishing interests either under an implied trust or based on those principles that we've just finally looked at around proprietary estoppel. As I say, well done. This is a very, very difficult area of law to grasp first time round, so I imagine you'll have to spend some time poring over both your textbooks and the key judgments that we've considered in this lecture. All the very best.